months ago. This has been going on for 6 months. But the prosecutor was delayed in filing it, and I wasn't pushing hard for it at the time, at the beginning, because we had plenty of work to do on the case. And I don't think there was any gamesmanship by the prosecutor. He's a young prosecutor, not that young. He's a completely good dude, completely honest, I thought. I still think. I don't want to say thought past tense. He's a solid guy. He's been very easy to work with. But there's a limit to how long we can wait for this motion, because we've got to get going. We've got to start talking to these people if we can. I need the names. And finally, just as the prosecutor is about to make the motion for the protective order, which will enable us to respond to the motion, which will enable a judge to make a ruling on the motion, which will hopefully enable me to get my hands on the witnesses' names, the prosecutor sent an email to the court announcing the following. This occurred in July. He was referring in his email to the court and to me that he was reading a Reddit thread about the case. The title of the thread was, quote, "This is the judge presiding over K. Flock murder case." And it discussed the judge in the case, a woman judge named Melissa Jackson. And the New York Post stated in the article that she is known for being one of the toughest and strictest judges in Manhattan. And there was a screenshot of an article in the New York Post about how tough she is as a judge. It was in the Reddit thread. And the prosecutor in our case, in his email to the court, noted that one of the posters in the thread wrote, quote, "If y'all was real K. Flock fans, you all would get the judge clapped." That means killed. And that's scary. The prosecutor noted, though, however, just from reading it, that he had no reason to believe that Kevin K. Flock either knew the poster, knew about the threat, or was in any way connected to the threat. Of course he wasn't aware of it. He's in jail. He doesn't have Reddit in jail. But the prosecutor then noted, "But I thought that I should at least bring it to the court's attention," and he provided a link to the Reddit post with the threat. So I'm concerned at this point when I read this email. Yes, K. Flock is not involved at all in the threat to kill the judge. So what? I mean, if someone around him wants to kill the judge and K. Flock is not aware of it, isn't that precisely the reason why the government would not want to give us the names of the witnesses in the case? Maybe someone around him would want to kill a witness. After all, they're willing to openly, publicly discuss killing the judge, apparently. So the threat directly impacts on this motion for the protective order that hasn't been made yet. And my thought was, well, why hasn't the government investigated the threat? I sent a letter back to the court noting that this was a threat to kill the judge. Where is the investigation? The prosecutor then wrote back and said it directly impacts on this motion for the protective order that hasn't been made yet. And my thought was, well, why hasn't the government investigated the threat? I sent a letter back to the court noting that this was a threat to kill the judge. Where is the investigation? The prosecutor then wrote back and said he's not planning on doing an investigation. Why? Judges get killed in America. They do. It happens. How do we know it's not a real threat? And if the judge is threatened publicly but doesn't know about it until the prosecutor brought it up, maybe now this is impacting her feelings about my client. Maybe she shouldn't be the judge in the case because she's prejudiced by it. I don't know. I didn't know. I didn't have a chance to speak to her when this email was initially sent by the prosecutor. But there's a potential motion to be made to ask the judge to recuse herself due to the threat that was reported against her. Maybe she thinks she can't be fair now. I don't know. She didn't write back to us and tell us a thing. I can't just ignore what the prosecutor revealed to the judge. I just couldn't. The threat. The basis for disqualifying a judge is a determination, in this instance, of whether the judge has an inappropriate awareness of an extrajudicial source, something that's beyond the evidence that she'd be seeing during the case, thereby resulting in an opinion on the merits on some basis other than what the judge learned from her participation in the case. That's the law. But here's the rub. This is interesting. Who decides for the judge whether or not she's to recuse herself, to be disqualified? Well, the simple answer is the judge herself does. And the law is clear. The decision is between the judge and her conscience. But even if she feels that she can still be fair, the law also makes clear that judges should avoid even the appearance of impropriety. So I wrote back to the judge saying, look, you haven't opined on any of this yet, but I want to talk about it. And we went to court last Thursday, and I wasn't there to make a motion to recuse, to disqualify her. I just wanted to hear what she had to say regarding the threat. How do we not at least hear her out? If I didn't ask her thoughts, I might never know if she was freaked out about the threat and needed to be disqualified. And I noted that the issue that arises from an email like the prosecutor sent regarding the threat to kill the judge is not limited to what the defendant knew or what he was connected to. I mean, that's part of it. But the more important part is the threat real? Is it credible? Who's the person who made the threat? And how does the prosecutor know that the defendant wasn't connected to the threat? He's just assuming. Has he done any investigation? I asked. Did you do any investigation? Oh, nothing, and I don't plan on doing it. No steps to investigate the comment. Again, my comment to the court on Thursday is, why not? The defendant's charged with murder, and the people, the state, have previously told us that they plan on making a motion for a protective order to prevent not only the defendant from getting the names of the witnesses, but they don't even want the lawyers, me, to get our hands on the witnesses. He's that dangerous, K. Flock, according to the state. That's what they're saying. Yet a threat exists online against the court in the name of K. Flock, and no investigation was done at all? I'm dubious, is what I'm saying. And just because the defendant, and again, in the mind of the prosecutor, on a hunch, without any investigation done at all, determined that Kevin was not connected to the threat, how do they know the threat isn't real? A threat like that, to kill a judge, regardless of whether the defendant was aware, surely is something to be investigated in a time period in our country where judges get killed. So if the decision, and apparently has been made, not to even investigate the threat is it's not deemed credible for no reason at all, what was the purpose of even bringing it to the court's attention if it's not a real threat? That was what I asked on Thursday. If you don't think it's real, why are you even telling us, except to inflame the passions of the court? I mean, why did it need to be passed at all? No one knew about it. Nobody read it. At least the defense lawyers and the judge doesn't. The prosecutor apparently does. And I explained that it was clear to me that the only aim of passing along this threat to kill the judge, which was apparently spontaneously deemed to be a non-threat, it's to prejudice the court at a time when a motion for a protective order regarding discovery, regarding the names of the witnesses, and a very important motion that, if granted, will make it nearly impossible for the defense to conduct any kind of meaningful investigation of the state's witnesses, that email that was sent with the threat to the judge, they sent it right at the time this motion is about to be filed. And the criteria for granting a motion for the protective order to prevent us from getting the names of the witnesses is obviously the concern for the safety of the witnesses. Also, what happened is that when this motion was initially brought up in March, when it was first discussed in front of the court, I indicated it to the judge, and